job of explaining. Whoops, there we go. Her blog post does a great job of explaining sort of the developments. And, what I'll say is, and I don't know that I won't get political, but, Texas isn't known for being super progressive on these things. Is that a fair statement? And this is a pretty progressive piece of legislation. I will say, and I alluded to this in the higher education setting on sex misconduct and sex harassment. Texas has probably the most progressive legislation in the country. So that is odd as it feels, one of the big themes. And again, Sandra's done a really great job on the Safe Institute's website, the blog post of explaining the law. I'll walk through it quickly with you all. I mean, they're basically three components to the change in Texas sex harassment law. The first one is, and this is, to me, probably the most significant one, is the expansion of who is and I put this in quotes, an employer under Texas anti-discrimination law when it comes to sex harassment. So in the past, to be covered by Texas anti-discrimination law, you needed to employ 15 or more employees. For purposes of sex harassment, now coverage extends to anybody who employs one or more employees. So the field of employers who now can be, Sandra alluded to this before, subject to a charge of discrimination with the Texas Workforce Commission or subject to potential litigation has expanded very dramatically to include anybody that has basically any sort of business operation at all. When I would go, when I've done in-house training programs, and this is the second part of this, one of the things I know like owners and managers would like for me to mention is, if you do this, you can get sued. And by this, I mean sex harassment, to threaten employees, to scare them, to kind of curb their behavior. And I would say that, but it was not entirely accurate. Whoops. Thank you. There's a lot going on in the news, that's for sure. But long story short, under this new revision to the Texas anti-discrimination statute, I'm just going to keep rolling with the punches. Under this new Texas anti-discrimination statute, that's real now. It looks as if there is not only liability potentially for employers, but for, and I'll just read it directly from the new statute, anyone who acts directly in the interest of an employer in relation to the workplace. And so there is a possibility now for the first time that in the hypothetical we were talking about, not only can a charge be filed against the company, but the person who is potentially engaging in sex harassment, and that person could be liable. I'm not aware of another state in the country, and I think I know this area reasonably well, that allows for that sort of individual liability. So that is potentially significant. The second part of the new, and there are basically three parts to the new Texas sex harassment law, is that there may be enhanced employer responsibilities about how we respond to reports of harassment. I say maybe, and I'll try to keep it as simple and straightforward as possible, but under the previous Texas law, the existing Texas anti-discrimination statute, employers, when they knew or should have known of sex harassment, were supposed to take what has been dubbed prompt remedial action, all right? And there were court cases that would fight out, well, what is prompt and what isn't prompt, and what does this mean, and all that sort of stuff. The new Texas anti-discrimination statute, and again, this only has to do with sex harassment. It doesn't apply to any other protected category, race, color, national origin, all the other protected categories, requires employers to take immediate and appropriate corrective action once they know or should have known of sexual harassment. So what's the difference between prompt and immediate? We will have to wait and see how this plays itself out in court cases, but it seems to suggest much more in the way, in addition, the addition of the phrasing appropriate corrective action seems to suggest that a much more vigilant response is going to be necessary when employers are put on notice of potential activity in the workplace that could be construed as sex harassment. So that's the second big piece of this new law. The third one is, and again, this goes back to litigation world and goes back to filing charges of discrimination with the Texas Workforce Commission. Historically in Texas, if someone was the victim of sex discrimination or sex harassment, they would have 180 days after that instance of discrimination or harassment to file a charge with the Texas Workforce Commission. If they didn't hit that deadline, then in essence, their right to file a charge with the Texas Workforce Commission would fly by the wayside. This new law extended that deadline. And so instead of 180 days, if you or an employee is the victim of sex harassment under the new law, you would have, in essence, another 120 days or 300 days total to file a charge without losing your right to file such a charge. So those are the three, in a nutshell, changes to Texas sex harassment law. Again, all of them very progressive. The first one, again, expanding the definition of who's covered. And this is literally at this point extending to virtually every employer in Texas, and perhaps more importantly, to individual supervisors. Second, probably, and we'll have to wait and see how the case law develops on this, enhancing employer responsibilities when we become aware of sex harassment. Now we have a responsibility to intervene immediately and appropriately. And then third, extending the deadline for employees who feel like they've been victims of sex harassment to file a charge of discrimination from 180 days to 300 days. So that's the short version of the law. I wanted to talk for a second. I am a lawyer and I can get fixated on the law, but I also am also a normal human being, and want to talk about some big picture things that I'm seeing in my practice. And I've done this now for almost 25 years, and that's why I probably have a lot more gray hair now than I ever have before. I want to give you some big picture thoughts. And I also want to compliment the work that Sandra is doing in this space. First off, one of the big picture things, so I want to talk about big picture, and then I would like to talk about some what I think are developing best practices. In terms of big picture, there have been tons of studies. I bring up this one. First off, about incidence rates of sex harassment. And I think we all can agree that the incidence rates are entirely too high, that whatever we've been doing in terms of prevention is probably not enough. And this gives you some example of that. This is a survey from 2003. There are more recent ones that come up with basically the same statistics. They ask women in the workplace if they've experienced sex harassment, and 50% of women say yes, which is a remarkably high number and frankly unacceptable. If they've experienced one or more specific sexually based behaviors, 75% of women. That if they've experienced had sexual, and there was another one, this is a different version, where if they've received unwanted sexual attention, coercion, or sexist or crude behavior, 60% of women responded that they have. And so, to me, I go, wow, these are intolerably high numbers. And if you go to studies, again, that are a little more recent, these numbers hold pretty consistently. And so it really does scream for a conversation about, if we agree that these numbers are too high, what are we doing systemically within our organizations to remedy that? Some of that's training, some of that's policy, and all that sort of stuff. I also think the next slide is pretty interesting in kind of framing, one of the challenges here. When and there've been tons of social science studies on this as well, and it's, again, really interesting. When employees feel that they are being sexually harassed, how do they historically respond to that sort of harassment? And you can see the statistics here. 75% will say, hey, I'm going to go out of my way to avoid the harasser, which is good, not probably exactly what you want. And frankly, in small workplaces, probably not a viable option, which now this law applies to. Attempt to ignore, forget, or endure is 70%. Seek support from friends. What is really low? The least common response was to take any sort of formal action, to file a report with the company. And when you look at the 6 to 13% who file a formal complaint, it is only after this has gone on for an extended period of time. And so, big picture, a couple of trends that we see. Number one, that we have a lot of activity that women in particular are feeling that they are being sexually harassed. And a lot of that is not coming to our attention until it gets really out of hand. And so one of the things that we work with companies, and I think, and I know Sandra does as well, and that I'm a big believer in, is like recognizing, acknowledging those facts on the ground, and how do we design thoughtful, responsive systems, knowing what the facts are on the ground? Because what we want to do, for a variety of reasons, because we're good human beings, we want to nip that behavior in the bud. Think of the hypothetical that we started with early, before it becomes, actionable sex harassment. It creates an environment that's so bad that somebody feels like they need to leave the environment. How do we do that? There are a lot of really interesting developing best practices, and I won't go into enormous detail about this, but what I will say is, if you look at the history of how sex harassment law has developed over the last 50 years, one of the big breakthroughs in the 90s was two cases out of the Supreme Court that are known as Farragher-Ellerth. And the short version of those cases is that the Supreme Court told employers for the first time that we think, as almost a matter of law, you need to develop policies so that if people feel like they're being sexually harassed, they report it. This was a super positive development at the time. But what we noticed a second ago was, if you look at studies, lots of people are experiencing sex harassment. Few people are actually using those policies. And so what are really thoughtful employers doing in this space to address those issues? And one of the things that we're seeing, and I'll just throw them out there, is rethinking our reporting policies and coming up with options for employees to come forward earlier, right? That may not be punitive. I do a lot of training around the country on restorative justice. That's an example of, like, all right, somebody feels like somebody is doing something that's making them uncomfortable. They would like to nip it in the bud. They don't want to get the person in trouble. They don't want to go through a formal investigation. Is there an intervention that might be appropriate to remediate. And I have found, at least for me, certainly at the university level, restorative justice has been used and utilized really well. I'm starting to see really thoughtful employers incorporate restorative justice practices into their workplace to create a more informal option than the traditional investigation, findings, discipline, all of that sort of stuff, which doesn't seem to be serving a lot of employees really well. The last part I mentioned, and again, I don't want to monopolize a ton of time, but this is super important. And when I will talk to, and I work with a lot of, I've worked with a lot of universities, certainly, and there's this sense of, we're getting all of these complaints, and I'm so tired of this. Well, or to view complaints as sort of threats. In addition, one of the things that we try to work with leaders around is to view complaints as an opportunity to address problems before they completely get out of hand and people start leaving workplace. And I think historically, there has been this view about complainers and complaints and, wow, I don't like that, and all that sort of stuff. And so one of the really important things, I think, and this is a cultural phenomenon that we need to have in our workplaces, is shifting the view of leadership about complaints as not necessarily something that's bad, and certainly not being upset at the complainer about bringing something forward, but as an opportunity early in a process to, number one, be informed of a problem, and number two, to address it. I will just say this, the employers that make me a little nervous are the ones you go and talk to them and you ask, in the last year or two, have you received any sort of reports of sex harassment? If they say no, that's either a really good sign that your training is amazing and you're changing, broad cultural, culturally influenced forms of behavior. Or, and this is more my experience, it means that there are a lot of things going on in the workplace that you just don't know about. And how do we create an environment where people feel comfortable coming forward? A lot of that starts with tone at the top and leadership, and soliciting those sorts of complaints, and having a robust number of processes. Some of them perhaps a lot more humane than the traditional legalistic report, investigation, discipline. And so when I see employers and companies engaged in best practices, these are some of the big picture items I see them covering.
Thank you, Scott. That is so helpful, and such good information. And this piece about the complaints really speaks to the work that we do around how do we see this as an opportunity? How do we get in front of it before there are additional complaints? I mean, we'll never stop complaints coming completely, but how do we see this as an opportunity? And I want to pause here and open it up and see if people have comments or questions for Scott. You can put those in the chat, but you can most certainly unmute yourself and share your question verbally if you'd like to. So what questions do you have? Yes,
I have a question, Scott. Can you talk a little bit more about restorative justice? I'm curious specifically about making sure that people feel safe and that restorative justice piece can happen without that need for that huge internal investigation, so that people do feel comfortable coming forward and being on the right line of the immediate line with the new law.
Yeah, so look, we do, I have a colleague and who works for a nonprofit, and we do some training around restorative justice that goes for 2 days. So I won't do that much of a plug here. Let me answer it this way. One of the important things that we talk about when we train around restorative justice is being mindful about when it is appropriate and when it's not. And some of that depends on the conduct at issue, right? If it's so egregious that you go, wow, the only appropriate response here. Restorative justice, by the way, assumes that whoever is the wrongdoer, the harm maker, is going to stay. And if you're looking at the sort of misconduct where that would not be a viable option, that it would give rise to a whole host of climate concerns, potential legal liability, then you might say restorative justice isn't appropriate under this set of circumstances. The other entry point is to look at the people who are participants and go, wow, is this an appropriate process for them? Is the person who is the reporter, does this person feel comfortable voluntarily participating in this process? Is this something they want? And on the person who's been accused, what we call the respondent, is there some acknowledgement that, hey, what I did was wrong, I'm so sorry for creating harm, and more importantly, is there ability, do we have a sense that there's an ability to accept some responsibility for creating harm, and more importantly, taking steps to not engage in the same sort of behavior on a go-forward basis. And so there are those sorts of screening. Not every case is going to be appropriate for restorative justice. Now, to go back to how does this fit within the grand scheme of things under the Texas law, I'd make a couple of points. I like the idea, if we accept the premise that the vast majority of what's going on in our workplace is not being reported pursuant to kind of the formal complaint processes, I'm a big believer in creating options for victims of harassment, as many options as possible that gets these folks who have been harmed in the door. And so the more options we have, I think the better. Not every case, and let me just make one last point. In my experience, the kind of lower level harassment that we see that doesn't rise to the level of something where I need to terminate, that doesn't rise to the level of severe or pervasive, kind of that definitional standard. The investigation discipline model really doesn't seem to be a very good fit for that's the results are pretty aren't very helpful in remediating that sort of misconduct. And so I do think a restorative justice approach, which by the way concludes with, and this is one of my frustrations with restorative justice, is there's a lot of airy conversation about it. And there's almost, I don't know how to put this, like I go to music festivals, I'm a hippie, all that sort of stuff. So, but there's this kind of hippie quality to it that I don't like. Restorative justice done well with, number one, making sure that these folks have been screened, that this situation has been screened appropriately, that number two, it concludes with, this is the way we're going to address this. And then third, that we monitor to make sure that whatever we've agreed to, a respondent has agreed to, or an employee accused of misconduct has agreed to, that they are in fact doing that. I think that satisfies our obligations under the Texas law to respond appropriately. It's the sort of intervention, what we're looking for are entry points. We're looking for processes where people will come forward, number one, and number two, that provide us with an opportunity to make sure that whatever is going on in the workplace that violates our standards, that violates our policies, does not continue when we become aware of it. And there are a lot of ways outside of the traditional disciplinary process to do that. And I'm very optimistic about restorative justice in that space. It's a long-winded, and I'm happy to talk offline too, but that's a long-winded answer to a really complicated question.
Thank you. Fascinating. And it's interesting because we looked at restorative justice options several years ago at formerly Safe Place, around domestic violence and sexual assault. And if anybody's interested, you can reach out to me or anybody there. And there's research out there. There are some forms of doing restorative justice in those areas as well. I'm seeing some questions. Julio has a question for you, Scott. He says, a clarification, Julio, would you like to read your question since you're here?
Sure. Thank you. I work with a nonprofit. We work internationally, but we're based south of Austin. And we work primarily with volunteers. We have a very small staff, but we have hundreds of volunteers. And my assumption is that those volunteers would be considered, especially by the law, as employees, or could potentially file claims as employees. Or are we just maybe being a little bit extra cautious in treating them that way and training them that way?
Yeah, so super complicated question. I'll give you a super simple answer. If they are really volunteers, in other words, we don't control them, they come and go as they please, they're not compensated. Legally, number one, they couldn't be sued individually for workplace misconduct. Number two, in theory, they're not our employees and wouldn't have standing to sue you under the Texas Workforce Commission Act. But the volunteers, to the extent that they're on site and create an environment that harasses our employees, we would be responsible for remediating their behavior. So they, for the most part, they're not going to be liable because they're not, under this definition, going to be considered employers. That's number one. They couldn't sue because they're not employees technically. And number three, what they do and what we tolerate, just like customers, for instance, we do have responsibilities to remediate their bad behavior to the extent they're engaging in bad behavior. Does that make sense?
Yes, thank you. And my other question, which is a little bit more long-winded, I think it'd be tighter about it, is kind of maybe like the story that we started with. It's a very tight-knit, kind of very inside baseball nonprofit. Like, kids get involved in high school, stay involved through college. So it's a very everybody knows everybody type of environment, which we value. However, we've had a challenge in trying to find reporting mechanisms that allow people within a very, very, very close, almost family type environment to feel comfortable and free to report. And I guess I know it's a big question, but are there any tools or kind of third-party nonprofits that step in, or different, I know you talked about different options, giving people different ways they can report? Because I feel that's where part of the value of the organization we've seen is maybe kind of like a hurdle, in that people may feel like they're reporting on like their uncle or their cousin.
Yeah, no, one of the counterintuitive things in this space, and again, this is borne out by a lot of social science research in a lot of different settings, is one of the biggest impediments to people coming forward with things that are bothering them in this area is whether it's familiarity, however you want to, whatever the cause is, I don't want this person to get in trouble. I just want the behavior to stop. And that becomes heightened when obviously people know each other and have relationships outside of work. And so, again, this is a hard thing, I think, for folks to wrap their head around. Historically, that's what happens under that set of circumstances. Nobody reports anything, right? Until it gets so bad that people, can't come to work anymore, or, they feel they can't do their job anymore because it's so pervasive, it's so severe. And so one of the counterintuitive things is to sort of recognize those dynamics and come up with informal ways for people to come forward and share their concerns and say, hey, look, this doesn't necessarily mean, I get it. You don't want to hurt this person. And in some cases, you might not have any choice. The behavior is so egregious that you need to intervene in a way where this person's separated from the company. But there may be less disciplinary ways for us to deal with a problem. Talk to them, go through a restorative justice process. The other thing I will say is, and again, this is really borne out by the social science research, is this idea of ethical fading. If people in leadership positions see this sort of small level misconduct going on. And it doesn't have to be addressed with a disciplinary process or informally, but don't speak to it and say, we don't, it's not acceptable. What ends up happening is employees start to go, wow, this is acceptable. And again, it's a whole phenomenon called ethical fading, and things can get worse and worse. So in addition to informal mechanisms, to the extent you see this going on and you're in a leadership position, I know it's hard to kind of be the person that says, hey, you need to cut this out, but the importance of setting the tone at the top in leadership and saying, I see this going on, it needs to stop, is also really important there. So it's a great question. That's the best short answer I can give you.
Thank you, Scott. There is one more question, and then we'll transition over to talk a little bit about what SAFE can offer. Cindy was asking, could you clarify or help clarify the issue of individual responsibility of supervisors? Would they be subject to Workforce Commission complaints and civil action? I see you, Cindy. Sorry, I jumped in. If there's anything else you want to say about your question, Cindy.
Oops. Okay. And I don't see Cindy, but I will just answer it. Yeah, no, under these changes to the, it's kind of funny. Sandra and I were talking about, she had mentioned, I went on the Texas Workforce Commission. They haven't updated their website to accommodate these new laws, but that is the most probably significant practical impact of these new sex harassment laws is, yes, I mean, in theory, I work at an employer. I'm in a, again, I don't know exactly what acts directly in the interests of an employer means, but I think it would certainly cover most supervisors. Let's just say hypothetically, this would never happen. Hypothetically, I'm a supervisor, I'm sexually harassing someone. The employee could then file a charge against both the employer and the individual supervisor who is engaged in the harassment. That could also, after you get the Workforce Commission, there could also be lawsuits that identified both the actual employer and that individual supervisor as being responsible for and liable for sex harassment. Now, I will say one last thing, and this is sort of weird. There are other protected categories, race, color, national origin, religion. The only protected category these new rules apply to are sex harassment. So, but yes, the answer is I could file a charge. I could say, I don't want to even file a charge against my employer. I want to file a charge against the individual supervisor because he's a jerk. That under this law, that would be permissible.
Can I ask a clarifying question there, Scott? This is Risa.
Sure.
Sorry, I'm cold and so I'm bundled up. So in that case, the lawsuit could happen against the supervisor if they were the one doing the harassment. Could the same be true if that supervisor didn't escalate the issue and report or didn't take immediate action? Could the liability fall in that way as well?
Yeah, I think that, and it's a great question. My reading of the law, and this could change with some case law developments, is no, that responsibility to, let me just say this, I'm not sure, number one. I think the answer is the responsibility to remediate falls on the employer, right, the actual company, whereas an individual supervisor couldn't be responsible for that. I think all the liability is focused on acts of harassment or discrimination facilitated by a supervisor as opposed to not responding appropriately. And again, I could be wrong about that. We'll have to see how this develops in subsequent cases, but that's my reading of the statute.
Wow, there's a lot there. My goodness, and so many things that we still don't know, right? Because we need to see how the case law develops, as Scott was saying. These are great questions, y'all. Thank you. And feel free to put more in the chat if you would like. I'm going to just move us along, and I want to be mindful of everybody's time and just let you know a little bit about what we do at SAFE Institute, if that could be of interest and helpful to any of you in your organizations. So coming back to this idea of, what is your company, your organization doing to get ahead of this, to be prepared? Scott talked a lot about setting the tone at the top. I mean, that's what is one of the things that's most important. You need policies and procedures, but what are the people at the top saying? What are they acting? Do it not, not just do as I say, but follow my model. And so how are you communicating your company's values and standards of conduct, and how are you acting those out? And then when you do have a policy, you do need a policy. That's why I put, do you have a policy? We've worked with small businesses that don't have them yet. What avenues are you using to disseminate that anti-harassment or sexual harassment policy? Is that something that an employee signs at new employee orientation as they're going through a whole host of paperwork and they just kind of sign it and move on and it's never shared again? Or is that something that's shared more broadly via email? Is it in a place where employees can easily find it? Is it sometimes brought up in all staff meetings, kind of going through it, or reminding people of what's in there? And then do you have reporting structures for sexual harassment that anyone can access? That means that the person working behind a desk 8 hours a day can access it because they know where to go. But it also means that the people working in your kitchen, if you're a restaurant, have access to it. And maybe they have access to, it regardless of the language that they speak. Do they know how to report, who to go to? Can they do that fairly confidentially, right? I remember working with an organization that does wonderful, wonderful work. But this organization's policy stated that if you were experiencing sexual harassment, you would go to, I'll call him John, but it was one person. There was nobody else to go to. There was no email to send it to. You had to go to John. And I remember having a conversation with them around what happens if a person isn't comfortable going to John. And I had a lot of blank faces like, well, why wouldn't they be? Well, doesn't mean that John's doing any harassing, but it's just there need to be more options. A person might not feel comfortable or safe. So what are the different options? And then what concrete actions is your leadership team taking to build that trust among employees so that they feel that if they do make some sort of a claim, that it will be taken seriously, that they will be treated with respect and validated, and that the case will be handled appropriately. We often talk in our trainings about starting with empathy and belief. And some of you may be doing this right now. Sometimes we get people kind of cringing and saying, how am I supposed to believe a claim of sexual harassment if I haven't even investigated it yet? And we're not saying you have to believe it at that level. You do need to investigate. But in the moment that someone is coming to you and saying, XYZ happened to me, it's important that we say, I hear what you're saying, that and validate. That sounds scary. Are you safe? How can I support you? What do you need? I'm sorry this happened to you. And as you're trying to find out more on how you can support them, it doesn't mean that you won't investigate, but it does mean that that person feels validated. And then how are you training your employees, your managers, to prevent harassment from happening in the first place and to effectively respond to it? And because it's not intuitive, a lot of trainings, a lot of companies have compliance trainings, and I understand that that's sometimes necessary, and that's fine, but I don't know that all of those trainings always approach the soft skills aspect of responding to claims and stepping in when behaviors are at a level where it's not yet rising to the level of sexual harassment, like Scott was saying, but there's things going on that could, if left out in the open, could become worse, right? Could escalate. So we at Safe Institute do training around building these safe and healthy workplaces. And we have developed a certification, a safe supported business certification, which I'll tell you a little bit about. I'm going to go through these slides a little bit quickly. They would allow you to attract new employees to your workplace or retain your talent, the talent that you do have. We can help promote your business. We will help you display stickers and posters to let your customer base and your employees know that you take this very seriously. And you would be giving back to the tremendous work that SAFE does with survivors of violence and abuse in the community, because again, all the proceeds come back to SAFE. Most importantly, in our work, you would be part of that positive social change, that culture change that's really needed. to stop harassment and abuse. And so if you were interested in becoming a safe, supported business, and we hope that some of you will, we would ask you to train 100% of your leadership team in our harassment prevention training. We would ask that you get at least 30% of your non-leadership team trained, with a roadmap to getting to 100%. So that might include incorporating the training into your new employee orientation. It could include doing trainings every 6 months or a year. But there's a way that everybody is going to get trained on how we prevent harassment and create healthy, safe workplaces. We would also review your harassment policies and response procedures, and we're looking for some of the things that I mentioned earlier around how responsive are they really to the people who are on the receiving end of harassment, or you might call it alleged harassment. We want that trauma-informed approach. And this is a certification that can be renewed annually. We're always creating new topics related to safe and healthy workplaces. We create new topics based on trends. In 2021, this is funny, we had started about June, we launched Back to Business training, where we were helping people navigate what workspaces when they come back to work. As COVID is kind of behind us, how do we renegotiate our boundaries and what we're comfortable with and not comfortable with? And of course, we were never able to completely roll that out. We've done bits and pieces of it in fits and starts with this evolving COVID situation. But most businesses can complete certification in as little as 6 to 8 weeks, which is really awesome. I think for a lot of businesses, that's important. And then again, we would recognize your business. We would be able to provide you with an hour of consultation after the training if harassment occurs at your business, but also we can provide further consultation. And we have a fee for additional consultation hours for that. You would continue to get invited to these continuing education webinars. And again, most importantly, you get to be to showcase the fact that you are a safe business that cares about its employees and its customer base. So how do we do this? We do these trainings in person or virtually. We do team trainings. We will customize the training to your business's dynamics. So it's a very different training if it's for a small restaurant as it is for a tech company or for a nonprofit that works in social services. And we can do them in person, COVID permitting. And so we're looking forward to moving towards that again. We have done a few over the last couple of years. Otherwise, we do them virtually via Zoom, and we have incorporated a lot of participatory exercises so we get everybody engaged on Zoom as well. We can also do self-paced modules for your employees. So what a lot of companies will do is have their leadership team trained, possibly have another group of employees trained, and then for new employee orientation, they will assign the self-paced courses, which cover the same content. So that's an option as well. And I want to make sure I'm not missing anything. We do all of these trainings in English and Spanish. They are available in both languages, including the self-paced online. And those self-paced trainings can be done on any mobile platform, on a laptop, on a phone. So it's really easily accessible. And before I take any last questions, I wanted to let you know that I am delighted to be a part of this team, but it is a team. I am not doing the trainings alone. I have one of our trainers is on the call today, Yenna, and we have Kiki and Vincent, who are also trainers. And that team is evolving. We're bringing on new trainers every so often. You might be interested to know that our trainers are actually safe staff. So these are people who bring expertise in the areas of violence and abuse and violence prevention, and really being able to have those trauma-informed, individual-centered interventions, which is really what we bring to this work. Most importantly, I think, which makes us stand out from maybe other companies that do more of the compliance training, which again, I agree is absolutely important. Some companies will pair the compliance training with what we offer as well. I have talked a lot in the last few minutes. I would like to see if there are any more comments or questions for Scott or myself, for that matter. So I will be quiet for a moment. I'm monitoring chat.
Well, let me just say one thing. When I talk about like really thoughtful responses to this issue, what Sandra just described is the package of everything you'd want to see. So that's exactly, I mean, this is it. So kudos to you all for this work.
Thank you. Thank you. It's been really good. I think a lot of people leave our training saying things like, wow, that was fun, or that was engaging, or I didn't expect this. And while we're glad that it's fun and engaging, we also have people coming back months later and saying, you know what, it was really important what I learned in how to respond to somebody making a disclosure, or we're seeing people who are using the 40s of being an upstander, so they are able to interrupt behaviors that might escalate, from inappropriate jokes in the break room to inappropriate touching, or just comments, compliments, things like that. And now, will the presentation be emailed to participants? Yes, we are recording, and so I am happy to send that out to participants. Thank you. All right. Well, I will stay on for a few minutes, but we are just at 12:58. If folks don't have other questions or you would like to wait, we'll be on for a few more minutes. Scott, thank you so much for your time. We so appreciate you and your expertise, and clarifying a lot of this around the new laws. Found that very, very interesting, which, you know, that could be dry. I find that fascinating.
Awesome. Thank y'all. It was a real pleasure. Thank you all so much.
I'm going to stop the recording now in case anybody's wondering.